It is Stephen Williams, founder and president of the CreditRepairShop.com, and I wanted to go over a quick summons answer where we just helped a client win or get a dismissal for a lawsuit. Now, this was from a debt collector that was taking them to court for a credit card debt that was purchased by a debt collection debt buyer. They sent the hired another attorney in the area. That's the way that they do it. The debt buyers buy the debt and then they hire out to attorneys or other debt collection firms in the area that people live in, and then they go and submit the summons complaint. They take on the expense of doing that part. The attorney for the area, that's their, that they don't have to go and buy the debt. So they do the lawsuit. They do all the grunt work to get everything in place, and then they split the profits with the debt buyer. So this is one that we did a response to, and I want to go through this because someone asked me, number one, that I just answered with the YouTube questions was that there's a lot of videos out there where they tell people don't pay a debt, and then they end up in a situation where they're being sued and they're in court, and you can't say, well, person on YouTube said that I don't have to pay this debt. The judge is just going to be like, they're going to be laughing at you and say, okay, uh, pull out your checkbook or get ready to be garnished for your job. So what we do for our clients and what I'm going to show you here exactly what you have to do. I don't want to say it's a simple process because they try to confuse you. They try to get you messed up. And if you don't respond to it the right way, you're going to actually help them uh, get the judgment against you. So this is the actual response that we used for this individual, and it got dismissed. So you can see here when you get the summons, and I'm not going to show the actual summons because for privacy, but in the summons there's going to be these numbers or there might be letters, and these are allegations against you. I always just say statements against you because I don't want to make it like you're a criminal, but technically these are allegations. And point number one was that this is the individual's name, and we said we don't dispute that this is the individual's name that you're trying to sue. Number two was the address that the individual lived at. We did not have any dispute. But do you see that we put no dispute to allegation number one, allegation number two? Then allegation number three was they stated that this individual that was in number one had gotten an account with the last, and they only had the last four digits on that account with this particular credit card company. And what we turned around and said is that I like full disclosure of the account number, not just the last four to establish it was my account. You have a right to do that. If you're the one that they're coming after for the money, you have a right to know the full account number. It could be one digit off, and that means that it's not you. Number four, please provide proof of a purchase of the debt, showing my name, full account number, social security number, mailing address, and original contract, because they stated that uh, this was purchased by another debt collection company. So we want to show this individual the proof of purchase of the debt. They can't just come to you and say that the debt is yours. They have to prove that the debt that they purchased is actually yours by showing the contract. They must provide the full account number, social security number, mailing address, and the original contract. That was the response on number four. Number five, please show proof of the charge off amounts, including all charges, my signature, authorizing alleged charges, my payments, balances, and interest rates disclosures. This was where they tried to state this is the amount that this individual owes. And we're not saying you don't owe it. We're just saying please provide proof of everything to establish the amount that you're trying to state. Now, in moving forward here, this is where they really tried to um, get the person mixed up. So if they might just say, well, I'm not going to respond to the allegations. I'm just going to skip the rest of these because they're just restating what was already stated. But you have to answer that. So we stated they had again alleged that number one and two, the person that lived it, person's name and the address they lived to, had the debt, and for three and said, and then we stated that we do dispute 3 through 5 because what they were trying to establish here was that the individual, which was 1 and 2, had the debts and the amounts from 3 through 5, and we again reiterated, I dispute 3 through 5. Then number 7 was please provide original contract to establish your claim. Number 7 was again where they restated the amount of the debt, and we restated that provide original contract to establish your claim. Number 8, I do not dispute my default. They said that the individual defaulted in with the debt. So we stated again, we're not running from it. We're just saying I did not dispute that I defaulted on the debt. I'm asking for full validation of the debt to establish paragraphs 3 through 5, which was talking about the amounts and who owns the debt to clarify that. Number 9, referred to paragraph 3 through 5 because they were reiterating again, trying to get the person not to answer this allegation in number 9 when they were basically just restating again 3 through 5. And then again, refer to paragraphs 3 through 5. They were trying to slip them up again. And we just said refer to paragraphs 3 through 5 uh, because this is what we're asking for. And then number 11, there are charges that I dispute, and the original creditor would have a record of those disputes. Eh, They tried to say that there are certain charges or that they had all of the charges, and he wanted to state that there are certain charges that he disputed, and the original creditor would have a record of those charges that were disputed, and they wanted them to get it from the new owner, needed to provide it to him by the time of the court date. Number 12, no dispute. Please refer to my request to validate the debt to establish a true amount. Uh, this was again to reiterate that we wanted to dispute uh, the number 3 through 5, but there's no dispute to the reference to validate the debt to establish a true amount. No dispute. This was where number 12 was again stating these two here, and we restated that we wanted to validate the original debt. Number 13, refer to paragraphs 3 to 5. It's like they just kept restating again the amounts, and we just referred them to paragraphs 3 to 5, which was to have a full validation of the debt. Then number 14, provide proof. 3 through 5 again. 15, provide proof. Refer to 3 through 5, which is his request to get the full validation and ownership and all of that stuff. Let's go here. Number 16, provide proof. Refer to 3 through 5. I'm requesting for number 17, requesting full validation of debt establishing amount claimed by the plaintiff. Refer to 3 through 5. This is when we say refer 3 through 5. That's what the defendant, our client, is stating what he wants for validation. And then number 18, bill does not establish a full validation of the debt. That's where they had just sent a bill stating that he owed that amount, and we restated that it does not validate the full amount, does not show a validation of the full amount of the debt that they're claiming, and that they needed to refer back to 3 through 5 for what he would want before they went into court. Now, this one here, person got lucky because they just dismissed the case because they wasn't going to be able to get this information. In other circumstances, the customer would have to go to court. And I always state you need to go to court regardless if they say that they're going to, unless they give you a document showing that they're dismissing it. You can't just go off of their words. But some of the times you will get a letter saying that they're going to dismiss it because they can't validate the debt. Some of the time they may say that they're going to dismiss it, but you still should show up to court to make sure that they dismiss it, because what they're trying to do is see if you don't show up, and then they'll get a default judgment. Other times you'll have to show up, and you may have to make this request again to the judge, and this is sent to the judge and to the plaintiff attorney. But you still have to show up, and you have to tell them that you want to see the documents. If they don't have it, they may try to ask for more time. That is your time to ask for a dismissal, because you have proof that you sent it to the judge with enough time, and you sent it to the plaintiff attorney with enough time for them to get the documentation to prove that you actually owe the entire amount that they're trying to sue you for. And then at that time, you ask for a dismissal. So hopefully this clarifies how you respond to a court summons and citation. And also, I hope you were able to see this, because someone said that I needed to use a larger font. So I kind of maximized, or I kind of moved in closer on what we were talking about. And I hope that this helps you. If you need help with your credit, please visit thecreditrepairshop.com. If you need your credit reports and scores, please visit your3scores.com. I really appreciate that. That's one of the ways that I help keep this channel up and going. This is Stephen Williams, founder and president of thecreditrepairshop.com. Make sure that you get notified. Make sure that you subscribe to the channel, because we need to get this information to more people. By you subscribing, you help other people with the information that I'm giving to you. You're also making it available to them because of the way that the algorithm works. So I really appreciate it. Please like this video, and please ask your questions and post your comments. Thank you.